Judges are the cornerstone of a democracy. They are entrusted with upholding the law and protecting the rights of citizens. Their decisions have, a profound impact on society. This power demands accountability. However, in India, the question of how to hold judges accountable is a complex and pressing issue. The Indian judiciary has faced increasing scrutiny in recent years. There have been allegations of corruption, bias, and misconduct. While the vast majority of judges serve with integrity, even a few bad actors can erode public trust in the entire system. The lack of effective mechanisms to address these concerns has created a crisis of confidence in the Indian judiciary. This essay will explore the challenges of judicial accountability in India, drawing comparisons with global best practices and proposing concrete solutions for reform. This is not an attack on the judiciary, but a call for introspection and reform. A strong and independent judiciary requires a robust system of accountability. Only then can justice be truly served.
India's legal framework for judicial accountability presents a paradox. On paper, it appears comprehensive, with provisions for impeachment, in-house inquiries, and contempt of court proceedings. However, in practice, these mechanisms have proven woefully inadequate. The process of impeaching a judge in India is exceedingly difficult and has only resulted in a handful of removals. It requires a supermajority in Parliament, making it susceptible to political maneuvering. In-house procedures for handling complaints against judges are shrouded in secrecy and lack transparency. The lack of codified rules and timelines allows for delays and inaction. As a result, judges accused of misconduct often escape meaningful consequences. They may resign or retire to avoid proceedings, effectively evading accountability for their actions. This situation undermines public faith in the judiciary and creates a perception that judges are above the law.
Many countries have established robust systems of judicial accountability that India can learn from. These models emphasize independence, transparency, and a range of disciplinary measures. For instance, in the USA, judicial councils investigate and prosecute judges like regular citizens. The UK has the Judicial Conduct Investigations Office, which handles complaints transparently. Germany uses special courts dedicated to addressing judicial misconduct. Canada has the Canadian Judicial Council, an independent body that accepts citizen complaints. Australia employs judicial commissions at both federal and state levels for accountability, and in South Africa, the Judicial Service Commission ensures transparency and layered disciplinary actions. These examples demonstrate that effective judicial accountability is achievable. By adopting best practices from around the world, India can strengthen its own system and restore public confidence in the judiciary.
The Chief Justice of India, or CJI, plays a pivotal role in the current system of judicial accountability. The CJI has the power to initiate in-house inquiries and grant sanction for the prosecution of judges. However, this concentration of power in one individual has raised concerns about potential conflicts of interest and the possibility of bias. When the CJI themselves are accused of misconduct, the system lacks a clear mechanism for redress. Furthermore, the requirement of the CJI's sanction for prosecuting judges has created a bottleneck, as seen in the reluctance to grant permission in several high-profile cases. This situation has fueled perceptions of impunity and undermined the effectiveness of accountability mechanisms.
Section 5: In-house shortcomings, a system found wanting. The in-house procedure for handling complaints against judges in India has been widely criticized for its lack of transparency and effectiveness. The process is shrouded in secrecy, with no public access to complaints, findings, or actions taken. This opacity makes it difficult to assess the fairness and impartiality of the system. The lack of codified rules and timelines allows for delays and inaction, further eroding public trust. The absence of independent oversight in the in-house procedure raises concerns about potential conflicts of interest and the possibility of judges protecting their own. This lack of accountability can lead to a culture of impunity, where judges feel emboldened to act with impropriety.
Section 6: Beyond impeachment, a spectrum of penalties. The current system of judicial accountability in India relies heavily on impeachment as the primary tool for removing judges. However, impeachment is a blunt instrument that is ill-suited to address the full range of judicial misconduct. A more nuanced approach is needed, with a spectrum of penalties commensurate with the severity of the offence. This could include warnings, reprimands, fines, suspensions, and, in the most serious cases, removal from office. A graded system of penalties would allow for a more proportionate response to misconduct, ensuring that judges are held accountable for their actions without resorting to the extreme measure of impeachment in all cases.
Section 7. Towards transparency. Opening up the judiciary. Transparency is essential for accountability. A judiciary that operates in secrecy is susceptible to abuse and corruption. India can learn from other democracies that have embraced transparency in their judicial systems. This includes making judicial declarations of assets public, publishing judicial orders and judgments online, and providing greater access to information about court proceedings. Transparency fosters public trust and confidence in the judiciary. It allows citizens to hold judges accountable for their decisions and ensures that justice is not only done, but is seen to be done. A transparent judiciary is a more accountable judiciary.
Section 8, a call for reform, actionable steps for India. To address the crisis of judicial accountability in India, comprehensive reforms are urgently needed. These reforms should focus on creating a system that is independent, transparent, and effective. Key recommendations include: establish an independent oversight body. This body should be composed of retired judges, legal experts, and members of civil society. It should have the power to receive and investigate complaints against judges, conduct independent inquiries, and recommend appropriate action. Remove the Chief Justice of India's veto power. The requirement of the Chief Justice of India's sanction for prosecuting judges should be eliminated. Instead, a neutral judicial panel should be responsible for granting such permission. Codify in-house procedures. The in-house procedure for handling complaints against judges should be codified and made statutory. This would ensure transparency, time-bound investigations, and clear guidelines for disciplinary action. Introduce a range of penalties. A spectrum of penalties, including warnings, reprimands, fines, suspensions, and removal from office, should be introduced to ensure proportionate consequences for misconduct. Protect whistleblowers. A mechanism should be established to protect whistleblowers who report judicial misconduct from retaliation. These reforms would go a long way in restoring public trust in the Indian judiciary.
Section 9. Justice delayed is justice denied, a global imperative. The issue of judicial accountability is not unique to India. It is a global challenge that requires a collective response. Judges around the world must be held to the highest ethical standards. When judges are perceived as being above the law, it undermines the rule of law itself. It erodes public trust in the justice system and can lead to a breakdown of law and order. International cooperation and dialogue can help share best practices and develop innovative solutions to this pressing issue. A fair and just world requires a judiciary that is accountable to the people it serves.